Welcome back to the Get Louder podcast. We have a very special guest.
Yes, we do.
His second appearance, David P. Shapiro.
He's in the house.
Thank you. I don't know if I should throw my hands up or start clapping or what. You have to tell me these things before we start rolling.
My job's to throw the hands up. It's fine. I'll do it every time.
Welcome back, man.
It's good to be back. Thanks for having me.
Awesome, man.
Last time I had you on, we had in theory, it was a badass setup. Practically, it was just a bad setup.
It just wasn't comfortable.
Yeah,
Sunken in the couch. Sunken in the couch.
It was by far the deepest couch I've ever sat on.
Yeah.
And then you sink into it after that.
I loved relaxing on that couch,
Yeah.
but for podcasting, there was no way to look good.
Not the suit. No. I had the legs crossed. I was showing off the sock, showing off calf. I was doing all kinds of that stuff. I looked at it. I'm like, all right, not what I thought it was going to look like. So glad to be back. Glad to do it in a more stationary movement.
People love them socks, man.
It happened. I've actually got a lot of compliments on that, which is funny because it wasn't intentional in the day.
Yeah.
But a little flair, mix it up a lot of times. The knock is I wear blue and gray suits, and I got like about 15 suits that I go through in my rotation. But sometimes on these videos, right, you look at it, it's like, oh, this guy only wears the same suit all the time. Not the case. So you might not be able to pick it up from afar, but at least the socks you could tell.
Like that was 3 weeks later, and it just happened to land on the same suit day. Damn it.
I'll take a picture of my closet next time.
Yeah. For real, let them know.
Hey, when it works, man. The suits look great.
Yeah.
I appreciate
On cameras, unless we get the really close, it's hard to catch the minor details that make each suit different.
No, I tell you what, though, this one I'm wearing today, I've not worn for any videos that we've done. So
Yeah.
Nice.
we're running out. We've done a lot of videos. We're running out of options.
Do you have a go-to spot for the suits? Would you get custom or take everything? I'm sure everything's tailored.
Give a plug to my guy Kevin Arroyo over at Bloomingdale's. Kevin hooks it up when he knows there's a big sale coming that we get some good buyback on stuff. We could wind up getting 25% off when it's all said and done when they do their promos.
Yeah.
So get high-end Armani suits, high-end Canali suits. Check out Kevin at the Fashion Valley Mall.
All right. That's where we need to go.
What do you think about actually talking about suits? What do you think about lawyers wearing suits today? You're starting to see a lot of new attorneys. They're not really big on wearing suits anymore, or at least not how the older generation wore them. It's more about dressing a little bit down, a little bit more casual. How do you feel about that?
Well, I mean, listen, you got to be comfortable in what you're doing, right? But sometimes people don't want to wear suits because they're lazy. They don't want to wear suits because they don't want to invest in their own look, right? And you got to be mindful that if someone's not taking pride in their appearance, if someone's not putting in the effort themselves, how they really servicing their clients. Now, that's not to say the guy in the best suit's the best attorney. A lot of times it's far from it. Mm-hmm. Or the person walking around in the ill-fitting suit is a hack. That's not always the case either. But you got to take pride in how you look. And what we've seen in a newer generation, I'm making myself sound a little bit older at 42, but in a newer generation, it's sort of whatever's convenient for them, not whatever's convenient necessarily for the role or what the role requires. So, you got to balance that between it. Us at our firm, the males at my firm, we're always wearing, at the very least what I'm wearing today, Monday through Friday. Weekend's a different story. Weekend, I'm rocking a t-shirt, a hoodie, a hat half on, unshaven, all that type of stuff. Mm-hmm. During the week, you got to play the role. You got to live that life, live that part.
Yeah, I agree with that, and I understand where you're coming from as far as dressing it down. But we could definitely dress it down, but still like you said, care about how you look, or make an effort to I'm not wearing a suit, but I'm looking good today. You know what I'm saying?
Correct.
And there's a big difference between just strolling in with your basketball shorts and your slides, and actually coming in and looking good.
Yeah, I mean, you see that a lot even in restaurants, right? They'll say, business casual, no sneakers. And it's like, yeah, but the sneakers I'm wearing are Ferragamo sneakers.
Right.
Or the sneakers I'm wearing whatever, right? And there's other guys, technically wearing shoes, but he looks awful, right? So, you got to figure out what works for you. But there's got to be a baseline of professionalism because the job and the title requires it. And a lot of people take that for advantage. And, it's unfortunate to see.
Mm-hmm.
Yeah.
So what, our mentor, he's on our ass all the time. Every time he sees one of our videos, he's sending me a message. He's like, I can't even take you serious, wearing a t-shirt. You should at least have a blazer on. And I was just like, how much of that really does matter? I ain't dressed like a slob, but do I really need to wear a suit in order to get to the next level in business.
Well, it depends what your audience is, right? And you want to be comfortable, right? So we tell our clients in our thing, hey, should I wear a suit? I want you to be comfortable. I want you to look professional, but I want you to be comfortable. And I don't want you to be uncomfortable in a suit if you could be more effective in a t-shirt. Now, you've been telling me that for a while too, about the mentor telling me that. All I've noticed is you're going to black t-shirts now instead of white t-shirts. So
They were slimming.
that's the only difference I know. But I tell you what, if you get you throw a nice blazer on there over top of that, you'll be looking good.
Is there a requirement though in court?
That's a funny story. Yeah, I mean, you should be wearing a suit or at least a blazer with slacks, right? As an attorney, not for the clients. Clients
The
can
judge.
wear, yeah, right. But for the attorneys, I mean, you should, as a man, you should be wearing a necktie. And the funniest thing is, we had this guy that was around for a while, that wasn't wearing a tie, right, in court, right. So he's rolling into court like this, but he's wearing like an ascot, but it's not really done. It's just sort of like wearing it like a scarf.
Right.
And like some judges had a real problem with that. And it was always interesting to see. It's like, listen, what's the origin of the necktie? What's the significance of it? It's a sign of respect, right? Just put on a damn tie. It's not that hard, right? To make an effort. But we've seen that with attorneys, and we've also seen it with clients. I'm always surprised, not our clients, but I'm always surprised when I see here in San Diego, people rolling in tank tops and shorts. Because I remember when I was interning in New York, judge literally, now how appropriate this was is a whole other issue, but a judge literally would ask, hey, how far do you live from here?
Go back.
Client would be, about 10 minutes? Why? He goes, all right, come back in 30 minutes with pants. You'd be in shorts. It's like, you got to show a basic level of respect, right? Now, there's a financial reason why people might not be able to afford nice clothes, and everyone should be mindful of that and respectful of that. But there's also, you've got a shirt with a collar, you've got a clean t-shirt. Don't be rolling in a ripped off or a cut off sleeve shirt when you're in court, because what's that showing is you don't care. And if you're a professional and you're not dressed appropriately, or at least cleanly, you're showing you don't care, right? You guys, it's a different story, right? This is a more casual environment, but try it out, see what works.
Right. We come booted every once in a while. We come suited and booted every once in a while.
I got some expensive jeans on. I got some expensive shoes on. The black T-shirt.
I see the jackets in the corner there. I don't know who they're there for you guys.
Those are actually
They're
Jason's.
not ours.
Okay.
Jason came with all his suits.
Man,
And
can I leave these here? I only got the McLaren.
he's like, I won't fit in the McLaren.
Yeah.
All right, cool.
we do come with buttoned up every once in a while, and eventually we're gonna make an investment. We're gonna go on a little shopping spree soon enough. And invest some in some swag and get some nice blazers and things like that.
The thing is for me is I like to feel like I can move. You know what I mean? I like to feel like I can move around. I'm not being constrained by my clothes.
Okay.
If I have to stop everything I'm doing and go into a full sprint for whatever reason, I can.
You never know when that's going to be.
You never know.
They're making everything stretchy now, though.
Yeah, that's true.
There you go.
And the times I have worn a suit, I feel badass in a suit. I'm like, I look good. But it's very uncomfortable, especially in San Diego. It's not that cold. It's not like New York. It's cold, so you get to put on the suit with the overcoat and everything, looking like a boss. In San Diego, it's like it makes it like when you see some government officials in Hawaii and they're wearing a Hawaiian T-shirt. You know what I mean? It's because you're dressed for the climate.
No, for sure. I mean, I came here from New Orleans in 2006, and that was the land of the seersucker. So you'd see people in seersucker suits because it'd be about 90 degrees with about 85% humidity.
Yeah.
And you also have to function, right? So it goes back to what you're saying. Be comfortable. I don't know. Start with a collar and then transition into a suit.
Have you ever rocked the Bermuda shorts?
Have I ever done that? No. And if I do, it's time for me to retire or put me down or something. Man. I can't do that.
You know what though? I do want to start getting the nice suits. Go hit the Armani shop.
Yeah.
Dress up, get fitted.
I like a T-shirt and a blazer though, because it's like you can keep the jeans on, you have the T-shirt, you throw the blazer over, it changes everything. You know what I'm saying? Like the whole like you just throw the blazer over this, it's a whole
Then if you need
other thing.
if you need to chase somebody down
and
the
then
street,
you just take it
drop
off.
the blazer.
Yeah.
What about jewelry though? Because I feel like if I already got the suit, I might have to get the rings.
Well, we need at least the watch.
I gotta get the rollie.
Yeah. I mean, what's weird about it is I don't wear a watch like at all, other than when I'm wearing a suit. So I'm out, I mean, for the most part, casual, certainly not like on the weekends, like around the house or whatever, I'm not wearing a watch, except when I'm wearing a suit. As far as other jewelry, I mean, I have a chain that I don't flaunt it out, that I wear, privately all the time, but not out over my suit. I've seen that before. That's an interesting look for an attorney. But yeah, I mean, it all depends, right? I mean, you got to have your own personality and you got to have your own flair to it while still being mindful of not making it about you as the attorney. Making it about your client, making it about the case, making it about the facts. Quite frankly, sometimes you don't want it to be about the facts. You want to distract from the facts. So you might want to make it about you, but for the most part, you never want the attention on you unless there's a reason for it.
Right.
And that's got to be something that you're going in with that mindset,
right.
Not just because you want the attention 24/7.
Right.
And that's when you break out the Bermuda shorts, is when you're trying to distract.
Well, for me, that's why I break out those socks that you see in some of those videos.
Hey, the viewers love those socks. They always bringing up the socks. So speaking of being the attorney, being a criminal defense attorney, and dealing with, in a criminal defense world, how did you get to a position where you're like, I want to defend those who they're looking at throwing them in a cage and throwing away the key and never the overlooked, you know what I mean?
Sure. Yeah. I mean, I sort of grew up in it in the sense that, growing up in New York, one of my brothers was a cop for a little while before he became a fireman. My other brother was a district attorney for 20 some odd years.
Wow.
Right. So my two brothers, my two role models in my family were on different sides of law enforcement, but still law enforcement, right? Cop and a DA. So I sort of grew up in that regard. So I always had a feeling that was someplace I was going to wind up. The issue was on what side of it. That all changed on April 26, 2004, when I found myself in the cage. Involuntarily. Now the joke is I go to jail all the time, but it's always voluntarily. I could always leave. Then I couldn't leave, right? And I got to experience firsthand what so many of our clients experience: the embarrassment, the fear, the anxiety, the shame of it. And decided at that point that, hey, I want to be part of the solution to making sure that people are going to feel that no matter what, but that there's a better day ahead and that we could be an assistance to that better day. And that's when I knew, okay, I was more likely to not, if not entirely, going to dedicate my career to criminal defense. And I was in law school at the time. So that was, I still had 2 more years of law school, but I knew that's the route I was going to go.
So, okay, cool. So in law school, when you're making that decision early on, does anything change about law school? Is there any kind of focus? So did you have to change your focus during school to be more criminal defense, or is it all kind of the same in the initial stages?
Yeah, early on it's the same thing, right? It's a basic principles, and I knew that 99.5% of the stuff that we were learning, I'm like, I want nothing to do with this.
Right.
I don't understand it. I never want to understand it. I don't want to do it, right? As you progress, second year or third year, you start focusing more on criminal law related issues.
Okay.
At Tulane in New Orleans, they had a fantastic criminal law clinic. So basically it was like, hey, let's play make-believe lawyer type stuff, for weeks at a time and get credit for it, as opposed to sitting in a classroom learning about theories and stuff that you could never apply in real life. So we're able to do it there, but you don't have to commit to it. I mean, there's people that graduate law school and have no idea what they want to do and fall in love with the career 20, 30 years down the road.
Got you. So that's where the Florida League comes from, is from law school being in New Orleans?
Florida League comes from New Orleans. That's where it comes. All of our marketing has the Florida League. That's a New Orleans connection. If you want to go deeper than that, the blue and white comes from before I went to law school. I was in college in Buffalo. That's white and blue colors for the State University of New York at Buffalo. So it's a little bit of where I've been, where I've come, and where we are now.
Nice. That's dope. You brought up something that made me think of a whole bunch of questions. So you said, now I go to jail voluntarily. I can leave whenever I want. And then that immediately takes me to the movies and TV shows. So how often are you going into, I guess, jail or bringing clients in and out of jail or talking in front of the cell? I always have that picture, the guys in the cell and the lawyers on the other side, what are you doing? Or something like that. How often are you doing that type of thing?
Yeah, I mean, it could be multiple times a week. I mean, there have been times I've been in every jail in the county in the same week.
Wow.
And there are other times you go a couple of weeks without. It depends how many clients you have in custody, right? And it depends what the needs are, right? Early on, you got to learn a lot about your client. As the case progresses, right, it's more just as updates come about. Sometimes you go check in on the client just to make sure that they may not have had a visitor in weeks or months, right? So you're there purely just to spend some time with them. But it happens a lot, right? And you have to be comfortable with that. It's not a fun place to be. It wasn't a fun place to be in the early days of COVID.
Yeah.
I'll tell you that much. When your clients are like, okay, they're not being brought to jail because half of, George Bailey down in Otay Mesa is alleged to have COVID. but I'm going to roll in there with, a KN95 mask and think everything's going to be good. Derobing outside your house and running straight to the shower was not a fun couple of months, but it had to be done.
Yeah.
Right. So it's, never a dull moment when you go see someone in jail, never a dull moment through those experiences. But I'm so blessed that for the most part, unless someone wants to keep you there longer, you get to leave when you want to leave nowadays.
Yeah, absolutely.
Nice.
Dang.
What when you hear about the defendants, you hear like 200 years to life, right? And they hire an attorney because they're like, I don't want that L, right? Why do they do so? If you're gonna get 200 years, which is technically life anyways, what's so important about dropping the life sentence, the L?
Yeah, that's a big word in prison, especially in the jails, right? Is that it is demoralizing, and we've experienced it with our own clients when they hear when a cellmate, when someone on the block gets a life sentence. We automatically will know, or we kind of anticipate, right? When they're calling, hey, I want to talk to you about it. We know going into that meeting that someone that they're close with on the inside probably just got convicted and is looking at life now, right? It is a mindset thing, is because you know that there's a chance you may never get out. Now, the law's changed a lot in California, especially in the last couple of years with elder parole, with youthful parole, where you could get out, you could have a gigantic number, even to an L, right, to life, but you could still get out maybe after serving 20 actual or something like that. The reality is that a lot of times people think that all hope is lost and that what's an attorney going to do for me if I'm facing that much time and I know I'm going down on something. A lot of times it can make all the world in a difference, right? You could beat those cases if the facts support it. At the very least, if someone's going to have to eat that amount of time, I mean, me personally, I want to make sure that I know exactly what's going on and know that if I'm going to have to eat that time, that I've done everything possible to make sure things were done the right way and give myself a chance to beat it.
Man, have you? Sorry, go ahead.
And so with that life set, so now the laws have changed. What kind of laws have changed in the last few years? Because I remember the last time I heard, if you have an L at the end of your sentence, that means you have no chance to ever getting out.
Yeah, well, there's life without the possibility of parole, right? So that still exists, an LWOP sentence they call it, right? Life without the possibility of parole. That means you're not getting paroled as the law currently stands, right? But there's situations where your client may be facing 150 years to life, but the reality is they may be eligible for elder parole, which says roughly after serving 20 years and after you've attained a certain age, you're then to be given greater consideration for parole. Doesn't mean you're going to get out, right? And you're trusting a parole board, half of them may be teenagers at this point who might be deciding your fate 20, 30 years from now, but at least you have a shot. Right? So there's youthful offender parole. So if you're under 25 or so at the time the offense was committed, you're to be given greater consideration for parole after serving a significant amount of time. It all depends. There's a shot. What's going to be really interesting over the next 10, 15 years is to see how this really plays out, right? Because what something looks like on paper, a shot, a belief, if it's not being put into practice by the parole board or by the California legislature to actually enforce it, we're not going to get very far.
Yeah. Have you ever represented somebody that you found out or that you proved was totally wrongfully accused in something like crazy serious, like murder or something crazy like that?
Yeah, I mean, without question, right? I mean, wrongful. There's a couple of types of things, right? There's the like the made for TV stuff, right? Where it wasn't me, I have an alibi, or I was there but I didn't do it, right? Then there's also maybe you've done it, but there's a viable self-defense argument, right? Or a legal argument that's I did this, but the law says I shouldn't be convicted of it. We've seen anything and everything, right? From low-end stuff to the most serious cases, right? One not guilty, client out the door after 17 and a half months in custody type stuff, self-defense homicides, right? Where the defense was, it wasn't that he didn't do it. He did it, but the law says he was legally entitled to. Right? We've had other cases where we had a client looking multiple victim type stuff or multiple accuser type stuff where the client was looking at 200 and something years to life, right? DA ultimately dismissed the case on the day of trial. Right, wow. So it's crazy, and sometimes just because a case gets dismissed doesn't always necessarily mean the client is quote unquote factually innocent. It just means the case couldn't be proven beyond a reasonable doubt, and a prosecutor acknowledged it and quite frankly did the right thing. Right, and that's a misconception. A lot of times people think that jurors think this sometimes, that in order to vote not guilty, you have to believe the client is innocent. No, you don't. It just means that you have to believe beyond a reasonable, or that the case hasn't been proven beyond a reasonable doubt that they are guilty. Right? And the best types of jurors, the most satisfying cases sometimes, are the ones where jurors will talk to you and say, I voted not guilty. I think your client did it. I just don't think it was proven to the level required by the law. Right? That's
Interesting.
like professional juror type stuff. That's where it's like, hey, this is why I think we should have professional jurors.
Right.
Because you have these standards that we long for as attorneys to hear the case, not be swayed by it, and still do their job.
Can any of those types of cases get rehashed later?
What do you mean?
So like, okay, I think he did it, but not to the extent of to be punished at this extent, blah, blah, blah. Like where I guess if it was proven self-defense, but then later on, like something of new evidence comes up. Or,
No, I mean,
okay.
once a case goes to a jury
Right.
and a jury reaches a unanimous verdict, right? Now, there's a different thing called a hung jury, right? If it's like 10-2,
Right.
then there could possibly be another trial, assuming
Right.
it's not dismissed, right? But a jury makes their determination. They say not guilty. That judgment's entered. That issue is done in the criminal forum. Now, there could always be a civil case. Right? I mean, the biggest example we saw of that was O.J. Simpson in the mid-'90s, right? Not guilty for whatever reason in the criminal case, and then he went down abruptly in the civil case, different burden of proof. You know, you can't just say, well, I beat the criminal case, I'm off the hook everywhere.
Well, that's sort of crazy because I heard in the civil cases, you can be innocent, but just because they don't like you or whatever, you could be guilty in the civil case regardless. What's so different about the criminal case versus the civil case, and would a criminal defense attorney help trial both?
Sure. I'll answer that last question first. I wouldn't unless I knew there was a very experienced civil litigator on the team with us, right? Because as far as rules of court, burden of proof significantly lower. That's one way it happens. People will tend to look the other way and not necessarily apply the facts to the law when we're talking about money as opposed to someone's liberty, someone's freedom, right? You know, so they may be more liberal in the sense of, okay, well, we're just going to make them pay, find them guilty, so to speak, in a civil verdict, right? And make them pay. There's a lot of different reasons. We know what we know as criminal defense attorneys. And, you know, unless we're going in with a professional who handles that type of stuff in that arena day in, day out, we're not going to touch anything outside of criminal defense.
Gotcha. What was the first part of the question?
Well, it was the first part of the question was how
What's the difference between the civil?
Well, yeah. Well, how can it be like you have a criminal defense, you have to show without a reasonable doubt, right? But in a civil case, you can be found guilty with no evidence that you're actually guilty. I think didn't this happen with Donald Trump, where he was found innocent in the there was no evidence that he did he like raped that one woman, and then in the civil case they're like, yeah, but we don't like you. You still have to pay.
Well, here's the difference, right? You just said found innocent. He was found, if what we're talking about is the same thing, he was found not guilty. It doesn't mean someone's innocent.
Yeah.
Right? And again, this is a criminal defense attorney saying this, right? And we say that because we want jurors to be empowered to vote not guilty in a criminal case, even if they believe that there was a lot of evidence that the client may have done what they're accused of, just that it hasn't been proven to that high level. Right? Civilly is a different story. Civil is a significantly lower burden of proof, and there are certain things that may come into evidence in a civil case that won't in a criminal case. And that goes to the importance of really having two different attorneys, or at least one area or one team that does a civil, one that does a criminal. But you want those people to be talking to one another so you could use each other's expertise to your benefit.
You know, and that brought up something else I was thinking, was with the juries, right? The jurors don't know anything about the law. How are they able to and they're paying attention to what's going on. They go, let's say it's a murder trial, and the guy is crazy. You point all these facts. It's all this lawyer jargon. How can a juror just convict you being guilty because they don't like you? Is that a thing, or is it they're like, oh, we have to stick to the facts? But then you have some people who are like, well, factually, you know, or you'll hear like, oh, the jurors can't hear about these text messages or whatever.
Right. Yeah, a lot of times the juries, the joke is it's like playing a game, like a board game you've never played before, and you play for the first half an hour and then you get the rules. In the sense that a lot of times they don't know what the law is, and jurors afterwards have said, well, we thought for sure that we were going to go this way until we actually saw what the law said, right? Until we saw the elements that needed to be proven, until you were able to argue a certain thing, talk about circumstantial evidence and differing interpretations, all that type of stuff, right? So, you know, they don't get to hear certain things. A lot of times it's for good reason, right? Because the law says they're not allowed to. But it is very interesting. And a jury can ultimately do whatever, right? I mean, we've had cases where we've been surprised, pleasantly surprised by the verdict, right? Where the client knew they were going down on something. We advised them they were going down on something, and they totally not guilty across the board. You've had other cases, admittedly, that every attorney who's tried enough cases where it's like, how in the world did that client get convicted of those facts, right? That's the risk with the gamble. These are 12 strangers in a community. Well, we tell our clients all the time, listen, this is why you want to take a negotiated outcome. This is why you want to go to trial. There are 12 people out there who can have jury duty in 3 months, 6 months, 9 months, whatever, that are going to determine your fate. You want to take that risk? We're down with you. But you have to understand that is a risk, because you could get a group of people that may not like you as the defendant, may not like your attorney, may not like the prosecutor, may not like the judge, may just be in a bad mood. And they're going to determine how this case winds up. And in a criminal case, though, you have to be unanimous. So it has to be all 12.
Oh, really?
Yeah.
So I guess it's called a hung jury. Like, what if there's just that one jerk? There's like, he's not guilty, and then, or he's guilty, and everyone's like, dude, he's not guilty. No, he's guilty. I don't like his glasses.
I've seen it on both ends, right? Usually, the holdout juror is the criminal defendant's best friend.
Really?
Right? Because, you know, in
How do they not get dismissed?
That's illegal, right?
No, because here's the thing, right? You don't have to agree. As long as you're willing to deliberate, right? As long as you're willing to deliberate in your position and follow the rules as a juror, you don't have to be unanimous, right? A hung jury sometimes is what you're hoping for if the facts don't necessarily support an outright acquittal, right? So there have been cases you play for the tie, right? It's like you play for the hung jury because you're hoping that either a judge or a district attorney will dismiss it, or you could be in a better negotiating position going on to try and resolve the case maybe for something better than you could have the first time. On the flip side of it is, you know, yeah, as great as it is to hear not guilty, and more importantly for your client to hear not guilty, 11-1 not guilty, more often than not, is going to result in a DA, if not the DA, the judge dumping that charge anyway and dismissing it. So we could live with that all day long. A lot of times, though, that one holdout juror is our client's best friend.
So in the jury selection process, that's not something that makes them not eligible?
No, I mean, that's something you weed out, right? It depends on the type of the case. If I think that my concern is going along to get along, right, where you're going to have maybe 9, 10 people in any given jury going to vote guilty just based on the facts, right? We're going to want people that are going to be okay standing for what they believe in, right? That are going to be okay getting told off after it's over, right? For keeping them there longer than they needed to be, for not reaching a unanimous verdict, right? Their job is not necessarily to reach a unanimous verdict. The hope is, at least the judge's hope is that, and the district attorney's hope is a lot of times that it is, but that doesn't mean a jury fails. A lot of times that means it's a success.
Right.
And that's stuff that we'll try and talk to jurors about. Like, hey, you talked about how you were on a hung jury 5 years ago. How'd you feel about that? Oh, I thought it was a waste. Well, why? You know, because we thought the person should be convicted. You learn a lot during the jury selection process in hopes that you get a better understanding of who these people are. Honestly, a lot of times it's a crapshoot because you get an hour max, right? With 50, 60 people, 70 people, whatever it is. You know, you're trying to learn about someone's life in a 1 minute conversation in front of 70 strangers. Right, but you know,
and their character and everything.
Right. But you have to go in like anything else, right? You go in prepared what you're trying to accomplish in this case, right? So I don't care if they're go along to get along. If I think our case should be, you know, hey, we want everyone to go along to get along. Right. All depends on your case. You got to know your case. You got to know your client. You got to know the facts.
Is it true that, let's say all the jurors are like, he's innocent, the judge can overrule that and be like, I don't care what you guys said. He's guilty. He's going to prison.
No, not in a criminal case, unless the parties decide that it's going to be a bench trial instead of a jury trial, meaning where a judge decides it. Right. Now, on the flip side, okay, what we will do a lot of times is after the district attorney rests their case, right, and they say, okay, this is the evidence we have, we will ask in civil. It's basically the equivalent of like a directed verdict, where you ask the judge that no reasonable jury should convict on these facts. And you ask a judge to basically interject and dismiss 1 count, 2 counts, all counts, whatever. Good luck with that. I mean, it happens once in a while, right? But a lot of times it's this hands-off approach. Let the jury figure it out. But if a jury comes back and they say not guilty, remember the difference between not guilty and innocent. Not guilty could mean innocent. Not guilty could just mean the case wasn't proven, right? That's it. Judge could be rolling his or her eyes. Judge could be like, hey, that's great lawyering. Judge could be really upset about it. Tough, right? The jury has spoken. Right, and that's a great thing if you're on the right end of that decision.
Right now, can you have you ever had one of your trials go to a bench trial? And Can you explain what a bench trial is?
Sure. A bench trial is where instead of 12 jurors hearing the evidence and making a vote, right? Is it unanimous, 12-0 guilty, 12-0 not guilty? Is it a hung jury? Do we not know, right? Can we not agree? It's where a judge makes that determination, right? And historically, we have not gone to bench trials, right? There's been a lot of discussion about it, depending on the case, though, right? So if you have a real technical defense, you're like, okay, I think that a juror is going to be swayed by emotion and want to, ring up our client, where a judge may be our only hope. Great. There may be other times where it's like, hey, you know what? We got 12 jurors. Only one of them needs to say not guilty, and our client doesn't get convicted here. Doesn't mean they get to go home. We may have to do this whole song and dance over in a year, but we only need one, right? And that's usually the guiding principle on why we don't go bench trial. But we've seen people do it with high levels of success. We've seen other people do it, and they regretted the decision 6 minutes into it, right? 12, you only need one of those 12. And if you go to a bench trial, it's one judge who makes that ruling.
Yeah. In your experience, how much is trial like the movies? As far as like,
Good question.
Yelling and
Yeah.
like dramatic closing statements
Yeah.
and dramatic, showing of evidence and questioning and all that stuff.
Well, I mean, there's a judge.
Yeah.
There's attorneys. There's a defendant. There's a
the
court,
bailiff.
There's a court reporter. There's a deputy sheriff, right,
Yeah.
as a bailiff. There's a gavel that maybe usually doesn't get used most times, at least not in San Diego. That's really it, right?
Yeah.
I mean, these things are entertaining, right? You go from they're arrested, and then 45 minutes later on some of these shows, it's like a trial that would take 2.5 years to get to trial nowadays, right?
Yeah.
The dramatics, it depends, right? I mean, is it, does the door open and some surprise witness comes in? No, you can't do that way, right? Can you ask, you could always tell sometimes when you're dealing with an inexperienced lawyer, because they're like cross-examining you like you're on TV.
Right.
And they're just saying stuff. Wasn't it true? And after you did that, it's like, no, I didn't do that. And after you did that, it's like, no, I didn't do that either. So, I mean, the dramatics works. It needs to be calculated. You need to know what judge you're before. You need to know your jury from the jury selection process. You need to know your case. You need to know when that comes out, right? Because if you come out hot and you're yelling and screaming about everything, you look like a fool. Right? But you could do voice inflection in your closing arguments. You could do dramatic pauses. You could do all that stuff. I mean, there's a lot of stuff that over the course of a trial, things that I will do originally didn't even know I was doing on purpose, but then it got brought up to me by other people at the firm.
Yeah.
I'm like, hey, why do you always clean your glasses? I'm like, when there's really bad evidence and I'm trying to act like I'm not paying attention because it's insignificant.
Right.
Yeah, why do you straighten your socks when there's really bad evidence? Because I don't want people paying attention to the evidence.
Right.
Right? I want them looking, what is this guy doing? Let's look at those socks.
So that's why he wears the socks.
Right. Now, I'm not getting up like in TV
Right.
and faking a cramp or whatever. It's just a subtle, whatever. Maybe I'll pour some water, whatever, right? There's stuff. Right? There's stuff that you do. I mean, you see that at every level, right? You see it in
Like checking
sports,
your
you
nails.
see it in business, you see it in life, you see it in whatever. But one of the first things we try and do, and first thing jurors hear, is like, hey, it's not like it is on TV. Right? And a lot of times prosecutors freak out about that because they're expecting, they're afraid that they're going to get jurors that are going to be like, yeah, the defendant admitted to it and half of the village saw him do it, but there was no DNA. There was no.
Don't need DNA in this case.
There was no fingerprints. I
Right.
saw on TV that you have to whatever, right?
Yeah.
So prosecutors freak out about that with all these CSI shows and all these high-tech shows because they may have a straightforward case and you get this wild juror who's like, I saw this on TV. So it plays an impact in having to address certain things that you may see on TV, but very different from real life. That's why people ask, what shows do you watch? I bet you watch all those shows. I don't watch any of those shows. One, I don't have the time for those shows.
Right.
And two, the stuff that I prioritize my time on is I live that stuff 12, 14 hours a day.
Right.
It's like, if I'm watching anything, if it's not sports or
The
news,
opposite.
it is mindless. It is
Yeah.
like rest.
What about a situation where you've discovered new evidence or realized something during a trial? Like, because you see in the movies where, like, I always think about like Liar, Liar or something where he like realizes like, wait, how much did you weigh? He's like, oh my God, da 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 da. Boom, I've got it. And then like, so, you know what I'm saying? Like discovery, like during the trial, like something that you didn't like do in your previous discovery.
Yep. Well, there are two things, right? There's one thing called trial psychosis, which is even the worst cases. You know, if you're really invested in a case, you're going to start believing you have a better defense than what you probably have. Right. So that happens a lot of times too. But it's also sometimes you will go down little rabbit holes. The goal is not to, completely get sidetracked, right, from what your theme is, what your theory is, because if you've prepared on the front end, you probably don't want to deviate too much from it, because then you're giving inconsistent messages to the jury as well. Right. But there's always something that comes up and it's like, oh, didn't expect they were going to answer it that way. Okay, does that allow us or give us some daylight to bust the door open to something that we didn't think we had before?
Got it.
Right, and that's the importance of having a general theme, but also leaving some room for interpretation, leaving some room for stuff, because stuff does come up. Now, surprise witness stuff, late discovery, not as frequent as certainly as you see on TV. Right? There's not that aha moment where it's like, I think we just won the case.
Right.
No, it's really not like that, right? And if it is, it probably is more of a product of luck and not being prepared, right, than anything else. So,
got you.
Have you ever had a if the glove don't fit moment, the jury must acquit? You know what? That makes sense. The glove don't fit.
Listen, not that dramatic, but there have always been moments, right? You want, especially on cases, right? And that was the epitome of it, right? What was the distraction, right? No one wanted to hear about the prior domestic from the defense, right? They didn't want the jury thinking about prior domestic violence history. They didn't want the jury thinking about possessive nature. They didn't want the jury thinking about the overwhelming evidence that he, at the very least, was one of the people on scene who was responsible for this, right? They wanted to focus on the glove. If the glove doesn't fit, you must acquit, right? 25 years later in these documentaries, we learned that he wasn't taking his arthritis medication or whatever, so his hands were swelling up, and they deliberately didn't take his medication the night or two before they baited the DA into having him try on the glove, so his hand was swollen, so it wouldn't fit into the glove. Right? So you focus on that. You focus on Mark Furman, who abhorrent behavior as one of the detectives on the case, admitting a known racist, everything wrong with, law enforcement, everything wrong with society, right? The focus was on Furman and the glove, right? And the right political climate for that case in that city at that time after everything that had gone on the years previously there. Right? So you can't go in there with some flashy slogan if it doesn't match up to the right case. But yeah, there are always moments like that you're like, oh, this is our theme, or what you may say on week one of trial in your opening statement, you're going to say over and over again in closing argument to tie it together, to also show the confidence in your defense, at least outwardly.
Right. So it reminds me of that meme. My client can't be guilty. He put it on his mama.
Was that not? Wasn't there a lawyer that was defending like Young Thug or something? He's like, honestly, Your Honor, that's cap. That's cap. But anyways. This new generation, bro. I'm like, I got to get out of here with that shit.
I haven't tried that defense. The stuff that we see is when they're talking to their mother about, coming up with defense theories on the recorded jail line. That's not helpful.
No.
Yeah.
So, you put it on your mama, but don't be talking to your mother about defenses on recorded lines, man. You can stay away from that.
Have you ever had a moment like, what's that guy, the Madoff? What's his name? Bernie Madoff?
Bernie Madoff.
Bernie Madoff, where he was... the first 3/4 or the first 90% of the case, it looked like he was gonna beat it, and then at the very last minute, the prosecution waited to drop this evidence that his son had made a Snapchat, and they had the video proving that he was there. Right? Have you ever had a case that was similar to that, where like you were like beating the case, and then at the very last minute, the prosecution showed some devastating evidence?
Yeah, I mean, the devastating evidence we knew was coming, right? Because that's been turned over and is part of the rules of evidence and trial and everything else and discovery, right? But the reality is there are ebbs and flows in trials, and there have been cases where we knew going in it wasn't a great case, and we walk out sometimes on a Thursday afternoon and say, this feeling's never going to get better than this. We know what's coming tomorrow. Tomorrow's 6 hours of damning evidence. So enjoy this feeling now. But the key is not to get too high, not to get too confident, not to get too low, right? Because when you're prepared, you know what's coming, and you could adjust it. Now, that may have been the feel-good moment, right? And then it goes off a cliff. And then even sometimes during a closing argument, right? Like, oh, all right, DA gives their closing argument. It's like, damn, your woman's going down in a hurry, right? Yeah. You get up there, if you do an effective closing argument, it's like, oh, I don't know. I think we got a shot. They do the rebuttal. It's like, all right, guilty, right? And then the jury's out for a couple hours, and you're like, all right, well, it's not embarrassing if they convicted. It's quick, right? It's not quick. Cool. All right, 4 hours, 5 hours. You start believing that stuff yourself, right? You just got to stay as even-keeled as possible. And again, it goes back to preparation. You know stuff's coming. You could adjust it. The right prosecutor, right? The best prosecutors we've seen are going to wait for the damning evidence at the end of a day, right? Sometimes hit you with it in the morning when the jury's awake if it's more technical. At the end of a day, we've had situations where going in, and this is going to be 3 hours of basically our jail recording testimony, which is damning to our defense, right? And then, 4-day weekend, this is what the jury heard last, right? The right prosecutors will know enough and be experienced enough to sort of sprinkle that in, and I'm sure that's what they did in that case.
Timing.
Yeah.
What is the relationship between the defense attorneys and the prosecutors?
Well, it depends, right? I mean, different jurisdictions, different areas of the state, different states are different. What I've seen in San Diego, having practicing here since 2007, it's for the most part really cordial, right? I mean, I've seen family law attorneys yell at each other and scream at each other in the hallway, and it's like, grow up. It's like, you're acting like your client or even worse, right? Civil attorneys fighting over money, acting like a fool and making disparaging remarks to each other and just being petty nonsense, right? Criminal stuff, yeah, I mean, there's bickering back and forth, but our approach is like, listen, you think we're being unreasonable, I think you're being unreasonable. Okay, if we can't resolve it, then we'll fight it. We'll fight it in court. It's like it's not like you see on TV with the dramatics, and you're gonna regret that decision, and you walk out, right? There've been a handful of moments that have sort of been like, wow, that was sort of like how it was on TV.
Yeah.
But for the most part, you get an inexperienced prosecutor, an inexperienced defense attorney, right? Or just someone who's not mentally well themselves, right? And they'll act up, whatever. It's like, all right, cool. Thanks. See you next week. Right?
Yeah.
I tell people all the time, it's like, don't talk to me like I'm my client.
Right.
I have not done what my client's accused of. 95% of the time, I have not nor ever will do what my client's accused of. Right? It's like, so don't talk to me like I'm my client.
Right. So don't slam the briefcase, get up and
Yeah,
walk
it's like,
out.
just don't. Yeah, it's like people do that. It's like, what does that accomplish, right?
Right.
Does that help out the client? Does that help out the case? Is there a moment for that? Yeah, maybe there is. Right? But you also got to be mindful of who you're representing.
Yeah.
Right? I have a real good relationship with a lot of prosecutors, just in a cordial, I think there's that mutual respect, right? And trust that I don't have to worry about them doing anything, shady. They don't have to worry about me or my team doing anything shady.
Right.
It's going to be a fair, hard-fought case, right? But you also need to be mindful of who you're representing, right? There are some clients that I'm not going to engage in banter with the prosecutor in front of them. Right? Because I don't want them running with that. Oh, he's not fighting for me. He's not whatever.
That makes sense.
Right? There are other times where it's to their benefit, right? To be seen outwardly with a positive relationship with the prosecutor, no matter what, right? So it's strategic, and that's what I learned over the years is that, everything should be calculated. Everything you're doing in law, everything you're doing in life, everything you're doing in business, there's no like throwaways or do-overs type thing. Everything should be like in baseball, like a waste pitch.
Right.
It's not really a waste pitch if it's calculated. If there's a reason why you're throwing the ball in the dirt on 0-2, right? Everything in life has to have a purpose.
Yeah. I wanted to follow up with a question from yours. So, how does the introduction of new evidence work? So, like, he says, I'll throw that devastating Snapchat video of you, da-da-da-da. Like, so how often does new evidence get introduced, like, part way or towards the end of a case?
Hardly ever, unless it's, like, rebuttal evidence, right?
Yeah.
So, say, for example, we introduce some evidence that, district attorney puts on their case, we call a witness, and they're like, because of your witness, now we need to open this door, right? Or sometimes you fight to keep stuff out of evidence. Judge's like, that's staying out, but if you open the door, all that bad stuff's coming in, right? And sometimes you do it, sometimes calculated decision, you may want it, right? Hey, you know what, let's take that chance. Other times a witness says something, you're like, oh, why'd you say that?
Right.
Now all this damning evidence is coming in. But for the most part, the oh, damn moment, right, from evidence is usually via an email that we download bait stamp discovery. Or we go and it's absurd, you got to pay $10 for a CD and you pop it in your thing and you're like, oh, there goes that case, right? Or something like that. It's not, it's not on the fly in court.
Yeah.
It's usually in the confines of our office
Got
or in our car listening to audio.
So it's not, they don't get a phone call like, really? So you got the video, you were able to scrape it off the network?
Yeah.
All right.
Yeah. Most of the time, we know pretty early what's up.
Yeah.
Have you ever been in a position where you have really good evidence on your client's part, meaning this evidence could get them off or prove them not guilty, right? But for whatever reason, the judge will not allow it in court.
Yes.
Now, what is the reason for that? Like, it should be, right? Like, look,
If it's real,
look at
yeah.
look at this video. He's not even at the crime scene at the time. It's Gio. It's tagged. Like, boom. And then the judge is like, won't allow it. Like,
What are the reasons why they don't allow?
Something that extreme probably would get in. We'd find a way to get that in. But we've had issues where stuff has come up. Why, not necessarily third-party culpability where we're blaming somebody else, but I think to give the jury context. And we think that may be a gigantic issue where, hey, if the jury heard that the reason why so-and-so didn't talk to so-and-so is because of something that happened 15 years ago, right, it would all make a lot more sense about why someone would either lie or be mistaken or be manipulated into saying certain things. Oh, that's going to go down, it's going to confuse the jury. It's going to waste time. It's going to be, sometimes the evidence code. Sometimes our biggest battle is what the evidence code is, right? It may be really relevant. It may be really important. But if we can't get it in, how are we going to get it in? A lot of times what our client may have said previously to the cops, right? If they are talking, sometimes it can actually be helpful. But we can't introduce that at trial because it's a self-serving statement, right? And then sometimes we're like, okay, even if we are able to get it in, we don't want all the bad stuff that we kept out. So, it's not a perfect system in the sense that, a lot of times people talk about truth and evidence, let everything out there, let a jury decide. Sometimes that's beneficial to our clients, sometimes it's not. But it is one of the more frustrating things that all you can do as a defense attorney is make your record, and God forbid your client gets convicted, and if there's a link to what was kept out, then you have a pretty good reason to appeal.
Have you ever defended a client who's a musician or an artist where he talked about his crime
In a song?
in a song?
I've had a couple that the DA didn't know about that we knew was out there about hitting
On
licks
Spotify?
and hitting licks and robbing people and all that stuff, and it was a robbery case, right? Okay, they didn't want to go there. I mean, the law's actually helped the last couple of years about what they're allowed to get into about that. Because for the longest time, it was like a rap lyric. All of a sudden, it means you're a killer. It's like, no, you don't, because 99.5% of people rapping about that stuff never even touched a pistol, let alone fired one.
Yeah.
Right? So, we've seen that, but bigger picture stuff, right? You get people just shooting off at the mouth on Instagram, on social media, on whatever, 6 minutes after they get out of jail. And they think, oh, Snapchat, it's going away, right? Good luck, right? Because the cops can't get to that. Okay, right? Okay. I can tell you about multiple trials where it's like, oh, I thought that was deleted. No, it wasn't deleted. You may have thought it was deleted. The cops knew it wasn't deleted, right? So there's a lot of stuff, right? Whether it's a rap lyric, whether it's a musician, whether it's an artist, whether it's a public speaker, whether it's a radio host. It's like, please stop talking about the case.
Yeah.
Please stop talking about the case. Don't make this any more difficult than it needs to be. And don't wind up getting convicted of something more serious based on your words than what your actions were that got you into trouble in the first place.
Yeah.
Now, if you're they're on trial for something, and can you is it absolutely in your worst interest to talk about? But what if you're innocent? You're you're going on these interviews. Let's say you go on this podcast. You're like, man, I'm innocent. They had me on some bull. Does that only hurt you, or does it look good to the public eye to see that you're defending yourself?
Well, it depends, right? I mean, it depends. There's a time. There may be a time and a place for that. There may be a forum and a place for that. But here's the thing, right? We've seen people, and it's been awful to watch, right? Where attorneys say, okay, we want a press conference, right? You're factually innocent. You're saying you didn't do this. Let's do a press conference. Okay, right. So you're thinking you're accomplishing. Adamantly denies the charges. This is a man of upstanding character, blah, 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 right? Okay, now they're going to make the mistake of opening themselves up to random questions, right, from the media. So was your client with the accuser that night, or did they know each other, right? And meanwhile, let's say the facts were they knew each other. They hooked up, but it was consensual is your best defense. Not that they're still factually innocent, right? They still are. But, right, that they got from the 0 to the opposing 20-yard line as far as evidence to get them there that something happened. And then the attorney's like, oh, well, we're not going to talk about that. What's the point of all the other stuff, right? You've just undone it, and now you're on camera. It can't be used against your client. Mm-hmm. But imagine if your client's like, hey, well, were you with her that night? Were you with her? Oh, I don't want to talk about that, right? So what is the end game of what you're trying to accomplish with going out and talking? Whether you're factually innocent, whether you're as guilty as the day is long, whatever the case may be, you have to understand what the purpose of it is and rely on someone who knows what they're doing to get some control over it. And if you're going to make a statement, beautiful. Let's work on that statement together.
Yeah.
Make the statement, get out of there. Don't be open up to a random Q&A when you have some skeletons that you're trying to keep out of the public eye.
Do you think that, like, for instance, like, if, like, you know how there have been recently, like, you hear about men being falsely accused of abuse, right? Do you believe that if the time, like, if you got found guilty for that, you do X amount of time, right? But if you've been falsely accused and you had to fight it and you lost money, you lost a good image in a public eye, do you believe that the accuser should face the same time that you would have got if you were guilty?
If it was maliciously done, right? Because again, there's a difference between beating a case because of insufficient evidence and beating a case because you were set up or
Right.
you were, totally fabricated, right? So if it was one of those where someone's vindictive and you never even, it wasn't like, oh, you put your hands on them, but it was self-defense, or you overreacted and you did a bad thing, but it wasn't as bad as what they said.
Just a total
It's a different
setup,
story.
though.
A total setup, right? Where you're caking on injuries, you're hitting yourself type stuff.
Yeah.
I mean, there has to be some consequences to that, right? Because the problem is those are the types of accusations when you're talking about domestic violence, when you're talking about assault in a sexual nature, when you're talking about all those things that will ruin reputations, will ruin careers, will ruin potential generations of reputation, generational wealth, depending on your status, right? Without a whole lot to back it up. And you got to take these allegations seriously because they need to be, right? For the longest time, these women or men who are making these accusations have been ignored. But you have to have some teeth to it, to the people who are using it to take advantage of the system, because arguably they're just as bad, if not worse, than the people you're trying to put in jail in the first place.
Right. Yeah, because some of that stuff can't be undone, like you're saying. Is there ever any type of like recourse in terms of reputation taken? Like as far as if you get caught setting somebody up, can the defense say no? You have to issue these statements publicly. Do you have to like do an apology? Say let nothing at like. How does it get from a marketing standpoint or a PR standpoint? Does it ever get solved?
Yeah, I mean more of a civil thing at that point,
Yeah.
right? Where and a lot of clients are like, oh well, this is all said and done. Can we go after her? Can we go after him? I'm like, you know what? I go, you might. I go, but that's an amazing conversation to have. You know why? Because that means we beat it. Right. I go, so let's understand if there's a statute of limitations on when you have to file something, we'll get you in touch with the right person who could tell you that. But the rest of it is like one step at a time, right? Let's beat the case first. From a reputational standpoint, I mean, we've consulted with like PR firms before and said, hey, what do you think we should do? This case is done. Sometimes you may not want to draw more attention to the accusations, right? A lot of times clients will say, oh, I got arrested, nothing got filed. I want to seal my arrest record. Okay, cool, right? You're entitled to it in a lot of situations, but understand you're now creating a public record court file where one didn't exist from just the arrest.
Right.
Okay, so if you want to do that, that's cool. But then someone goes down to the courthouse and say it's me. I get arrested, falsely accused, and nothing gets filed. They go say David Shapiro 5/18/81, no record. I file a motion to seal my arrest record. David Shapiro 5/18/81. Okay, cool. Here's now this that I was arrested on this date. This is what I was arrested for. Here's the paperwork outlining all the facts that are in dispute.
And you just put yourself out there when you didn't even have to.
Exactly. Yeah. That's why you have to, what is this accomplishing not only today, but tomorrow, next week, next month, next year?
Right.
And that's in every decision you make in a criminal case, good, bad, or otherwise.
Right. Crazy.
What was the most heinous case you ever took it on?
Heinous.
God, there's been a decent amount. What is a heinous case depends on different people. We've had cases where judges have commented that it's one of the more egregious and heinous cases they've seen in their career. And these are judges that have been judges longer than I've been born, or been in doing criminal law longer than I've been born. And we're like, this wasn't even the worst one we took on this week, right? And there have been other cases where we were like, oh my God, this is like behind closed doors, we're uncomfortable with these interactions. But DA wasn't really tripping on anything. DA was reasonable in their negotiations. I mean, listen, anything involving children or abuse of some way of children is a dynamic that, admittedly, a lot of defense attorneys don't want to touch, right? They may feel too connected to it. They may not want the backlash from the public. They may just say, hey, I'm at a point in my career, God bless, where I only want to do these types of cases, right? My whole thing and our whole thing in our firm was not taking certain cases assumes that we don't find the conduct equally as offensive and wrong, right? So younger in my career, everyone's like, David, you take all these sex cases, you take all these violent cases. I bet you'll change that when you have kids. And now I have a child, and I never understood that because my mindset has never changed. It's not like I thought that was okay back then.
Right.
I find it equally as offensive and disturbing right now, but we're also mindful of false accusation. We're also mindful of overcharging certain cases. We're also mindful of someone who might have not necessarily a legal defense, but a lot of mitigants, meaning a lot of reasons why they're in a different situation and should be punished differently than other people. Mm-hmm. Even though the conduct, there's no excuse for it under law and they need to go to prison for a significant amount of time, there's still a lot of things that we find out that, hey, there's more to it than that. This person was abused too, or this person didn't have the life that they think, right? Doesn't mean you should walk out and not get any punishment, but it's a way to separate yourself from that, right? You're doing a good job defending the rights of your client, making sure they get the best outcome that the law provides. Mm-hmm. I have no problem handling these most heinous cases, and no one really at my firm does, right? And that's a big differentiator with a lot of other people that won't touch certain things. We're confident in what we're doing. We're confident in the beliefs, and we're still citizens of the county, the city. At the end of the day,
right.
We get it. We get it.
Did you ever see that movie, Law Abiding Citizen?
I did not, no.
Oh, man.
Sounds familiar. What's it about?
Man, that movie's crazy. It's Jamie Foxx and whoever played the Gladiator.
Russell Crowe.
I mean, not Gladiator. What's the dude's name?
What's
The movie's about Jamie Foxx is a criminal defense attorney. He's like the best in New York, and he has like a perfect record. And he ends up taking this case where these guys basically kidnapped whatever dude's name is. Oh, not 300. The guy who was 300. Remember that?
Sure.
Yeah, sure. Anyways, they bust into his house. They kill his wife and his kids, like all this crazy shit, and then they leave him alive. And then it ends up going to trial. Jamie Foxx is his attorney, and then Jamie Foxx, because he doesn't want to ruin his perfect record, says, it was really this guy. Like, this guy's gonna get the death penalty, but the other guy, he's gonna get off. It's like, this is the best deal. We should just take the deal. And then dude was just like, Gerard Butler, that's his name. And he's like, no, they're guilty. I was there. I saw the whole thing. Like, we need to fight it. And Jamie Foxx said, no, we're taking the deal just to keep his perfect record or whatever. And then it closed, and then he ends up going back and killing the dude and doing all this crazy stuff afterwards.
Okay.
The movie's wild. You have to see that movie.
The most wild thing about it, that's an example, again, of Hollywood and TV.
Yeah,
right?
exactly, yeah.
Any criminal defense attorney who wants to talk about their perfect record, that means they're not trying any cases.
Exactly.
Let alone multiple cases in a year or over the course of their career, right? Because so many times people are, what's your win record?
Right.
Right? I go, okay. Sometimes I'll tell them, it's like, what website you find that on?
Right.
Right? What, I'm like, you understand we do criminal defense, right? Mm-hmm. And you understand that a lot of times it is not, you could go to trial on a 5-6 count case, and you could beat the one count that keeps your client from that L, right? And your client and you and your team are ecstatic with that result. And other people are like, you lost 5 out of 6 counts. It's like, we conceded 4 of them.
Right.
Right? And now the offer was 15 years. The max my client could get is 12. It's like, that's a win.
Right.
That's huge. Right? But, win-loss record. What does that really mean?
Right.
It's easy to have a good win-loss record if you're trying petty thefts and, 0.10 DUIs as a new attorney.
Yeah.
Right? But as you start trying cases sometimes because there's no other way to go, you can't settle them, you got to try them, then you got to find the wins within, okay, client was looking at this, or we beat this count, this enabled them to have this type of classification in prison, this enabled them to get custody credits at this amount. Those are really the wins when you really start digging into it. So when people ask about perfect record or whatever, that's
because it's never black. It's never black and white. It's like always multifaceted, right?
Yeah, but there's always multiple counts. There's always multiple charges. There are times where we've tried cases where we've gone in and said, this happened exactly the way they say it happened. But it happened when so-and-so was at a certain age, not at this age. Mm-hmm. Right? So convict of these lesser offenses, not of what they're charged with.
Right.
Client knew, we knew, they're going to prison. They're getting rolled, they're going to prison.
Yeah.
Right? But that would have been a huge win in that situation. Even if you hear guilty 18 times, if it isn't what you're going charged with.
Right.
Right? And now your max is 10 and a half versus 24 at 2/3.
Right.
Huge.
But definitely.
I think the funniest way I've heard about how to hire a criminal defense attorney was Andrew Tate made this statement how he found his defense attorney. He's like, I went to the first office and I was like, I've committed multiple felonies. What's gonna happen to me? They're like, well, you're gonna do some time. But maybe we can strategize it. You get like some time served, this and that. He's like, not good enough. Leaves, goes to his next defense attorney. He's like, I've committed multiple felonies. How much time am I gonna do? He's like, well, there's things we can do. This guy right here, he shave his head. He looks like you. He did it. You do no time. He's like, you're hired.
Things we can do.
Yeah, I'll reserve comment on that. That's the thing, right? People see that and they come in and they want this immediate answer and they want whatever, and you got to balance that, right? Because you got to also be mindful if someone's got all the answers on a complicated issue right away, that means they're shooting from the hip and they're just telling you what you want to hear. Right. So that's where you got to run away. Somewhere in between we don't know. It's like just establish a short-term plan, let it lead to a long-term plan, and if things work, they work, and that relationship works, and it should work out fine.
Absolutely. So you got this book over here. Why don't you tell us about that?
Look how young I looked.
Switch to the camera.
There we go.
That was a book, Facing Charges in San Diego. Here's what you need to know to regain control of your future, right? And that was a book that I wrote a couple of years ago. Basic questions answered, like, what happens at an arraignment? What's bail like? What should you look for in a criminal defense attorney? That type of stuff. Because I thought about, there were a lot of questions, basic questions that we kept getting over and over again at our firm from potential clients, even from current clients who maybe hadn't worked with us for a while. And I was like, let's put that stuff out there, right? And let's put it out there under the umbrella of that I have been on that side of it myself, right? When I was arrested in 2004.
Right.
And that's the whole thing, right? Our trademark slogan, right? Slogan's like it's a bad thing, people think. We help good people regain control of their future when charged with a crime, right? I wrote that for me in 2004, right? Most everyone who gets arrested, I'm a good person, I didn't mean any harm, whatever, right? I'm a good person, I got my whole life ahead of me. And what are they concerned about, right? Whether it's jail, whether it's reputation, whether it's a job, that's their future. Right. And what's the biggest thing when you don't have control over things? You panic. And you have that feeling inside of you like I don't know why like the world's crashing down, right? You're watching a sports game, you freak out because you have no control over the outcome. Right. I'm more anxious sometimes in life watching stuff like that than I am going into a big trial because at least I know I have some control over it. Right. How I perform, how we represent our client. So the whole purpose of the book is just education. Right? Education. Hey, I lived through it. You can too. This is what you need to know. Right? And the more education you have in the early steps of the process, I'm not expecting a ton of people to read this book before they go on a crime spree. And say, I read that book. Cool. I'm not going to talk to you, detective. I'm not going to have all this incriminating, damning evidence on my cell phone and on social media. I'm going to line up a bail bondsman before I get taken into custody. Right? But it's important. A lot of times families have found valuable information in there. That book in jail with clients are like, hey, I'm always looking for something to read. Right. Here you go. Right. And they've said, hey, so-and-so wants a copy, so-and-so, whatever the case may be. Right. So it's all about understanding what your options are. And the more options you understand you have, everything from how you handle the case and who's standing by you in that moment, the better decision you'll make, whether that's with us or whether that's with anybody. Right. Right. So we've had a lot of success with that. I mean, it's on Amazon. You could order it. It's kind of funny. When for a while early on, I was trying to identify who the people were in my life that bought the book, right? But it's all about resources. We have it on our website. You can download it on the website. I'm actually going to do an updated version in 2024. Hopefully, be out no later than 2025 to get that information out there for everybody.
Absolutely.
Definitely let us know. We'll be purchasing one.
We will.
What are three of the dumbest things a client can do when charged with a crime?
Okay, there's a lot more than three, but let's try and break it down. The first is to be penny wise and pound foolish, right? A lot of times people will make a decision based on the cost of the law firm or the cost of the attorney instead of the value, right? And you have to look at this as an investment because even a traffic ticket, right? Not that we handle traffic tickets, but even a traffic ticket will have more consequences than, oh, I don't want to have to go to court. I don't want to have to pay a fine, right? You think about insurance. You think about points on your license. You think about all that, let alone a severe crime, right? And people try and cut corners, and they hire law firms to cut corners and try and save some money, and they want to pay tenfold later on, as opposed to doing it right the first time, viewing it as an investment into the extra money I'm spending now. The return on that's going to be tenfold later on if I get the result that this firm is capable of, that this firm probably is not, right? So that's one. Don't be penny wise and pound foolish when it comes to your future, your freedom, your reputation, right? Another is this idea that, stuff on social media, stuff on the phones, talking in jail, all that stuff, after you've been accused of a crime, well, they got what they got. They're not watching anymore. Depending on the case, they are watching. And the worst thing is when we beat the case on the original charge why you got in trouble in the first place, and you go down because of some nonsense you did after you got out. Because you didn't pay attention. You didn't listen to your attorney. You didn't get the right attorney on the case. And the other is sort of along the lines of this penny wise and pound foolish, but it's, I'm going to wait and see. Okay? I met with you. I like your firm. I like these two firms. But you know what? I haven't been arrested yet. I'm going to wait and see. Well, here's a story about that. Okay? January of 2020, we get contacted by someone who's under investigation for murder. Okay? That individual and their family reach out to the firm. There's discussions about possibly coming in on that case and being hired to represent them during the investigation stage. We're reaching out with San Diego police or law enforcement. We're reaching out with the district attorney's office, all that type of stuff, right? Because of that wait and see approach, right? Fast forward 7 months. There's now 7 months of damning evidence that's going on social media. 7 months of damning evidence on cell phone stuff that we could have at least told that person not to do. Whether they do it or not, it's a whole other issue. And then when they get arrested and they get put in a jail cell with a paid snitch, and they've got a recording that never would have happened had they had an attorney.
Hold on.
Wow.
A paid what are you talking about?
snitch?
What's a paid snitch?
Someone who gets paid $1,500.
To
At least that's a going rate.
to be in jail?
$1,500 to be brought into a cell to have, in this context, it was in a gang case, and you bring in someone who's basically, if it's a younger defendant, you bring in like someone who's portrayed as an OG, been there, done that, to get that person to start talking and to start making admissions, whether it's to puff themselves up as credibility or whatever the case may be.
How's that legal?
It is legal before the arraignment. Because you're not appointed an attorney. You're not appointed an attorney from the public defender's office unless you come with one before until the arraignment. So had that individual not adopted the wait and see approach, we would have been in contact with the DA's office, police department, anyone and everyone. Now, would that have made the end outcome differently? Maybe, maybe not. But what it would have prevented would have been that 3-hour jail recording. Right? And everyone's like, oh, it's a snitch. You should be able to tear up a snitch. Yeah, okay, cool, got it. I know how to do that. But what am I supposed to do when there's a recording of it? It's not just them saying, oh, dude told me this, this, and this.
Right.
Oh, you're getting paid $1,500. You're facing time. You want to be in bed with the DA. You want to be in bed with the cops. There's a recording.
Yeah.
Right? So then you got to attack the context of it. But the wait and see approach, critical mistake. Right? You make impulse decisions in every other aspect of your life. But when it comes time to getting someone to protect your freedom, your future, your reputation, literally everything in your life, you're going to wait and see and relinquish whatever control you could regain over the situation. The biggest mistake we see.
Don't wait.
Don't talk to
see.
nobody. Don't talk on the
nobody.
phone.
Keep your mouth shut.
Hire the best attorney you can hire. How important? That's my attorney right there.
Yeah. Always and forever.
How important is it having a criminal defense attorney on retainer?
Well, I mean, some people come in and say, "Oh, I want you on retainer." It's like, okay, well, have you been contacted by anyone? No. You think you're going to be contacted by anyone? No. Right? And honestly, then it's just if it's a true retainer, right? Okay, we could talk about that. But in reality, the second you are accused of a crime, the second you commit a crime and you feel it's only a matter of time until someone comes knocking on your door, or the second you're arrested, right? That's the most obvious. Act. Keep your mouth closed, right? protect what's important to you, know what's important to you, identify what your options are, and get the best quality attorney you can, because you could see, you want to stop, you can't control anything what already happened. You know, we all could change things differently in life. I would have changed how I handled April 26, 2004, and the months and years before then a lot different than what I did. But you know what? Once I got out, right, actually when I was in, I was able to start effectuating change, start effectuating decisions that were going to help me regain control over that situation. And it started with the right attorney at the right time, right? And then to actually listen to that attorney if you trust him. Because otherwise you're just pouring money, right? Whether it's a retainer or anything else. There's 10 grand, 20 grand, 30 grand to do the complete opposite of what we're telling you to do.
What do you think about, once a year I go through a phase where I like to watch all the mob movies. What do you think about the mob attorneys?
It depends. I mean,
The other one's on retainer.
See, right? Those are the ones on a retainer, right? Where you can make a living just on, you know, you get in with a couple of people and you have your career made right there.
Yeah.
Listen, I mean, the old days, I wouldn't put it past that a lot of that stuff with money changing hands and everything. It seemed like that was pretty common. Nowadays, it's not as common, and if it is, they do a hell of a lot better job of hiding it. So in general, though, you know, like anything else, right? It's over dramatized for TV. You know, you hope that not everyone is as sleazy looking as some of the attorneys that you see. You know, you think there's some of the movies, but I mean, these are, at the end of the day, these are experienced attorneys who know what they're doing, have the connections to know the right people to talk to find stuff out for the most part. And you know, like anything else, right? You're not going to be trusted by someone on the other side of that table who doesn't believe that you're capable of getting stuff done, right?
Have you ever met any attorneys like that?
Oh yeah, every day. every day. I get a book just on that. Not on mob attorneys.
Yeah.
Let's be clear about that. Not on mob attorneys, but just on attorneys in general. It's like, my God, think of all the things you could be doing in life. It's like, what made you decide to wake up and say, I'm going to be mediocre at best at this for 40, 50, 60 years. It is mind-numbing because you see over and over again people that spend money that they probably don't even have to settle for mediocrity on a good day. As to who's representing them.
So what makes a mediocre defense attorney versus the top of the best like David Shapiro?
Couple things, right? One is you have to have a basic understanding of the law. Right, so if I need to
just a basic.
If I need to do an estate plan, right, I'm not going to hire a criminal defense attorney no matter how much I trust him to do my estate plan, right? I'm going to hire someone who's familiar with that, right? So you have to be a criminal defense attorney, not an attorney who does criminal defense, and there's a big difference there. Attorneys who do criminal defense, it's like door law, whatever comes in. Oh, I'm really a family law attorney and I do immigration, but you know, if it's a simple DUI or something like that, I'll take it because I don't want to turn away $5 grand or $6 grand or whatever. Right? That's dangerous, right? We don't mess around with that. Someone calls, they need a family law attorney, we put them in contact with a family law attorney. So you want someone who handles exclusively the area of law where your case is, in this instance, criminal defense, right? So that's number one prerequisite. You also don't want to make the mistake of going into situations where, oh, so-and-so has been doing this for 30 years, they're better than someone who's been doing it for 20. Or so-and-so has been doing this for 10 years, they're better than someone who's been doing it for 4. Because the easiest analogy, right? And this is something that we talk about to clients, and no matter how you look at it. If you're a golfer, right, we all know people who've been playing golf for 30 years, whatever, and they still can't break 100. And they play every day, and they stink, right? I played golf a long time ago, right? And my objective was to break 80 every time I played. If I didn't break 80, I was very upset, right? I haven't played golf. I've literally hit two balls in the last like 7 years. Right? I could probably go play golf right now and break 100 easily. Right?
Let's go play golf.
But not break 80.
There's someone who's oh, they've been doing this for 30 years. This guy's out of it, whatever. Right. But I still have that skill set. Right? So if you don't get blinded by years of experience, right? You could also say in any sport, right? Who's your cornerstone of a franchise? Is it the journeyman who's been around for 13 years, who's been okay, had some flashes of excellence, but for the most part, you know, is any given moment about to get kicked out of the league? Or someone who's been doing it 3-4 years at the highest of high levels, right? That's who you want to build around. That's the type of attorney you want. So don't get blinded by experience. Look at quality of experience volume of experience, not just years of experience.
So how does one identify quality of experience and volume?
Sure. What you're looking at too is what is out there, right? So if you're going there and okay, I'm going to hire this attorney and let me check out their website, let me see what they're doing recently. I mean, there are some telltale signs, right? And it doesn't, and I want it to be clear, it doesn't mean because if an attorney does this, it means they're any good. It just means something you should look at, right? So if you go to a website and you're like, oh, this attorney's been around for 30 years and their photo is 25 years ago, okay, should you have any concerns that this person's not up with the times, that this person's not really doing stuff recent, or they're talking about the awards they won in 1997, not the awards they won in 2022, 2023, 2024. You know, their press clippings of their high-profile cases were in 2004, not in 2023. Right? So those are telltale signs that this person may have had their day, but they're out of the game. Right? So you want to find that sweet spot of experience in years, experience in quality, right? And someone who is relevant in the field today. And you could do that. The internet's a beautiful thing. There's websites, there's social media. You also want to look at who actually is a team, right? So how do you differentiate, right? There are a lot of fantastic solo criminal defense attorneys out there, right? Men or women who've been running their own shop, doing everything for 20, 30, 40 years, right? They're great lawyers. But the issue is they may be great lawyers a case here or a case there, right? If they're in trial for a month, who's running the business? How many people are they really helping, right? So you want a firm. You want a team, right? Oh, I want my lawyer to answer the call 24/7. It's like, no, you don't. No, you don't. Because if you got someone who's always answering the call, that means they probably don't have a whole lot of other cases. They're not in demand. There's probably a reason for that. And you want nothing to do with it when your kid's future's on the line, or your reputation on the line, or your wife's freedom's on the line, right?
Yeah, that's an interesting balance because people do talk about that a lot. Like, I could literally never talk to my attorney. I could never get them on the phone. Like it seems to be like one of the biggest complaints.
And justifiably so.
Yeah.
Right? Now, the middle ground, where that sweet spot is that we've been talking about between no communication,
right,
and sure, what do you need? Hold on, let me tell my daughter to be quiet, right? Because it's 8 o'clock at night on a Saturday, and you want to ask me when your court date is 6 months from now because you can't read the email. Cool, right? The middle ground is that's the importance of having a team, right? So yeah, there's always someone there for you. And we are very big about scheduling. Great, you have a call. Let's give you your undivided attention, 15 minutes, 30 minutes, 2 hours, 4 hours, whatever it takes. But to understand that during that time, we're going to focus on you, we're going to focus on your case. And there are other times when you're going to call and you may speak to one of our assistants who could schedule you for an appointment. Or who, quite frankly, can answer your question in 3 minutes as opposed to waiting 3-4 hours for your actual attorney to get back to you. Right? So you want to look at the depth of that firm. You want to look at the history of that firm too. Right? We've seen in 17 plus years, 18 years here in San Diego, a lot of fly-by-night firms come and go. Right? They're hot for a couple of weeks, they're hot for a couple of months, they're hot for a couple of years. Right? You want sustainability, you want someone with some longevity, and all else being equal, work ethic. Right? Because you could post about it, you could talk about it, you could say, oh, I'm about this, I'm about the cause, I'm about always standing up for my clients, whatever. But at the end of the day, if you got 1 foot out the exit door at 5 o'clock, or you got 1 foot out the exit door at 4 o'clock, you're like, I don't work weekends. Okay, cool. You know what? Because there's people that are who are just as good as you, and that's the differentiator. Right? And again, on the flip side, you don't want your attorney always available, but you want to make sure they're out there, and you want to look at what they're doing in the community. Right? Are they a ghost to the community that they're serving, or are they a fixture in the community that they're serving? Right? Doesn't mean they're a better lawyer, but it means they have that sustainability. It means they have those connections. It means that that's one piece of that puzzle.
Man.
David, how do you sleep at night defending all these criminals?
I think you're going to say, how do I sleep doing everything I do? When I do sleep, I sleep well. And I sleep well knowing that I never condone the conduct, right? And I represent clients at a high level in ethical, responsible fashion. Right? And at the end of the day, as long as I'm doing that, it's a service, because if the cops aren't protecting your rights, who is? If the district attorney's not protecting your rights, who is? If a judge isn't protecting your rights, who is? It's a criminal defense attorney. Right? So everyone wants to, gotta be careful what I say here with my language. Everyone wants to be negative towards criminal defense attorneys. until they need one, or until they really peel it back and understand that it's not about getting the bad guy off all the time. If stuff is done the right way, if an investigation is done ethically, legally, right, then the evidence is what it is, right? And a good lawyer may be able to get you a better chance of beating a strong case, of course, right? But if the evidence is what it needs to be, then that's on the prosecutor if they can't get a conviction.
Right.
Right? Blame the jury. They're good at that. Blaming the jury when they don't get the convictions, right? Not their fault for trying a case that shouldn't have gone to trial. It's the jury's fault.
Right.
Right? As long as you're doing things right, making a positive difference in the world, and being able to utilize a platform that we have, being able to help so many people for good, I'll always sleep all night. Whether I'm sleeping 4.5 hours a night or whether I'm sleeping back in the glory days of 7, 8, 9, 10 hours a night.
Man, like, you know what's funny is like if I want if you do the math, right? You're saying about someone who just wants to get off at 4 o'clock, right? Let's say you put in 8 hours a day, 40 hours a week times 52. That's 2,080 hours a year you're putting in if you don't take a vacation, right? Well, let's say now your competitor is putting in 10 hours a day plus 4 hour, 2 half days on the weekend. So that's an extra what?
8 hours. Extra 8 hours a week.
That's 18 hours a week, yeah.
An extra 18 hours a week.
Plus, I said 10 plus 8.
So it's 40.
900 hours.
40 plus 18 times 52. Yeah, 976 hours.
Yep.
Yeah.
So your competitor has 976 hours every year. Let's say over 5 years. Within 5 years, your competitor will have 4,880 more hours of time put in than you. You'll never be able to catch up to that person.
If that's what your goal is, right? And if you're content, and there are reasons why people do that, right? Reasons whether their mental health, whether their family's made an executive decision, hey, I'm only going to work this many days, that's cool. But when you're looking for the most serious cases, right, you need to know that the attorney, that the team has the stamina, has the ability, and is all in on doing whatever it takes to get you the best possible outcome, right? Not all in within their framework of what they're willing to give. All in. That's what distinguishes, we believe, the good from the best of the best, certainly here in San Diego.
And that's why you're the best.
That's why. David P. Shapiro.
David P. Shapiro. You know what I do whenever a new law is made in California? I want you to come onto the podcast and talk about it.
Okay.
It
has to be a criminal law, otherwise I probably won't understand it.
No, a criminal law specifically.
Yeah.
Okay.
Like there's been a lot of laws changing in California now.
For sure.
I remember when I was growing up, like they were very harsh on crime. They were just giving out strikes to people.
Yep.
Like who didn't like
Anything.
Do you know about this? The strike system?
Yeah.
Bro, they were giving strikes for non-violent offenses, and they're not allowed to.
It was with 2 strike priors and a 3rd felony, and and the felony didn't need to be a strike.
It could be It could be a misdemeanor, right?
The felony didn't need to be a strike, and for a while, I mean, the extreme example was you have a couple of petty thefts that gets elevated to a felony. You've got 2 strike priors. You're stealing some food or whatever.
Yeah, you're doing life.
You're doing 25 to life, right? Now it's got to be the 3rd strike's got the case that gets you sent to 25 to life under 3 strikes has to be a strike, right? And it's even more complicated than that, and more convoluted than that. But yeah, it's moving in the right direction. There are some areas of the law that's not moving quick enough.
Yeah.
Right, but it's moving in the right direction. And whenever there's something certainly that'll affect the masses, I'd love to come back.
Well, real quick, so I know you gotta go. Like we're busy people here, but real quick, like right now, right? Like whereas before it was like too crazy. They're just like, it's like, was it the prison industrial complex?
Yep.
Where they just want butts and bunks. You know what I mean? Yep. But now it's sort of like where it was so harsh. Now it feels like, and I could be wrong, it's becoming way more lenient to where you just see people just rushing into Targets, stealing everything. No one can do anything. It's chaos. People can just wreak havoc to you, and they'll get out on that Monday. Where do we find this balance?
Yeah, I mean, I think that what the change we've seen is on the non-violent stuff, right? So when you're talking about thefts, whether you're talking about simple possession or even transportation of narcotics, we've seen a change in the prison complex, right, or the industrial complex of build more, right, we'll fill it type mindset, and more towards evidence-based practices, more towards rehabilitation, more towards understanding that a little more investment on the front end, where the easy solution may be to send you to prison, could protect you and generations for a long time, right? On the violent stuff, people are still going to prison for a long time on violent offenses, especially here in San Diego. You have outliers here and there, but it's continuing to change. Obviously, one thing we're seeing a lot of, social media, internet, out there publicizing things, some of which may be true, some of which maybe not. The looting, so to speak, of large department stores is a problem. It's a problem for the consumer, right, who's going in there trying to buy stuff. Our prices of goods are going to go up. We're going to have to pay more to make up for the people who are stealing stuff, right? It's a problem for these companies and their security guards who are given instructions not to put hands on these people, right, not to defend property. It's a very interesting time, especially here in California, as we're trying to balance all this out, right, between, in one regard, not just opening the doors and let everybody out to wreak havoc, but also really being selective in who's coming out at what time and what can we do to invest in the 13-year-old or the 14-year-old so they don't wind up being the 45-year-old who's getting out of prison without any skill set.
Right.
Yeah, that's a beautiful place to end it. But because we go even deeper and deeper, and I'm trying not to because Brandon's side-eyeing me right now.
We'll be going for an hour 25.
I'm just joking. I can't.
It's a quick one.
I wonder who our first 3-hour podcast is going to be with. But it ain't going to be today.
David, man, as
appreciate
always,
it.
that was
Appreciate
awesome.
Thanks.
Thanks.
Appreciate you. Thank you for the book.
Yeah.
Plug in your socials, your website, your phone number, where people can reach you.
Sure. Phone number 619-295-3555. Website is davidpshapirolaw.com, David P, S-H-A-P-I-R-O, law.com. On there, you get to all our social media. Just go to the website, top right. You'll find us on Instagram, on Twitter or X, whatever it's being called now, LinkedIn, all that fun stuff.
Definitely check that Instagram and be staying tuned for that YouTube.
Yeah, and if you're in San Diego, definitely, and you're in trouble, hit up David. He's the best. I'm not a lawbreaker. I'm a law-abiding citizen.
But we got him in our corner.
But we got him in our corner in case we need him.
Glad to be there.
Yeah.
All right.
This has been another episode of the Get Louder Podcast. We out.